All right.
Thank you. You may take your seat. Good morning. We are on the record today. 28th Circuit Court here in Wexford County. We're taking up the case of people of the state of Michigan versus Aaron Francis Michaels Elijah. This is case number 24-13773FH. Francis?
On behalf of the people.
And I'm Jeff Pierce, and I'm here on behalf of Mr. Michael. He's next to me at the table.
All right. Thank you. Also here this morning is Miss Lindsay Simmons. She's the agent from the Michigan Department of Corrections, serving as a probation officer on this file today. We are here today for a hearing on a probation violation allegation. There was a request and warrant for probation violation filed on or about July 15th of this year. It alleged 2 counts of violated probation, specifically involving alleged threatening behavior or assaults toward another individual. What are we doing today, Mr. Carnes?
All right, I believe we are having a hearing.
All right, thank you. You may begin.
Thank you, Your Honor. The people call Amanda Connors.
Ms. Connors, come on forward.
And Your Honor, I just asked the court to take judicial notice of his bond conditions.
I'm going to do that right now. Ms. Connors, your goal is a seat right next to me. All right, before you take a seat, I'll swear you in. No, you're all right. I don't know why everybody does that, but when I stopped them, yep, come on up here. It's okay. It's because the podium's in the way.
Yeah.
Please raise your right hand. Do you swear or affirm the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth? Thank you. You may have a seat. And before you begin, Mr. Carnes, 1 second. Don't know why I can't find them so readily, but 1 second. Oh, there they are. Court takes judicial notice of the terms and conditions of probation that I signed on or about April 8th of 2024, and that were subsequently acknowledged by the defendant on or about April 16th of 2024, and they are in the public file here before the court. You may continue.
Thank you. Can you please state your name and spell it for the record?
Amanda Connors, AMANDA,
And do you know an Aaron Michaels Elijah?
Yes.
How is it that you know him?
We've been dating for a couple of years.
Okay. Can you tell me what happened on July 13th, 2025 at the Cadillac Resort on M155?
Yeah, it was a complete misunderstanding, honestly. There was a dispute. We were arguing, yes, and he was trying to calm me down. And I had thought initially that, because I was looking towards my kids, I had thought initially when he had reached towards me that he had hit me in the face. So I did text my kid's dad to come get my kids at that point, after sitting there on it and talking to him. But not only him, my child also witnessed this, saying that, no, he did not touch you at all, Mom. Like, that's what happened. So the cops came, but also my kid's dad did, and beat the crap out of him. And that was pretty much it. The cops came, I told them the truth of what had happened, that I had thought he had hit me initially. That's not what happened.
Okay. Did he make contact with something else that then hit you?
I think the phone is what hit me in the face. I don't know if he actually touched it or if he touched my arm and what hit the phone, but the phone hit me in the face. So I did get hit in the face, but it wasn't with Aaron's hands by any means.
But so he did shove you or something?
He was-
attached to you?
Objection, mischaracterizing the witness's testimony.
No, he didn't shove me.
Hold on. We're going to take a break.
Sorry.
You all ramp up like that and get excited. I don't know who answered what question at what time. When the next question was asked, when the objection came, it is like a car crash. So I can't even rule on the objection. Go ahead and begin by asking your question.
Yeah.
Thank you.
Okay. So my question was, and Your Honor, we're at a probation violation.
I got it. I can just go ask the
So my
question.
question is, did he hit either, did he push, I won't say hit, did he push either your phone or your arm during this argument?
Not to my knowledge, I'm not positive how it happened. Honestly, I'm not. Like, he was grabbing at my arm, like, trying to calm me down, and I wasn't even looking in that direction.
Okay.
So I'm not positive if it got bumped out of my hand and hit me in the face, or if it was my arm, like, you know, when he like reached towards me, because I was trying to like pull away at the same time. So I didn't see exactly what popped me in the face, but my kid said even, and he's a very honest boy, that he saw everything, and it was the phone that hit me in the face.
So, did your children, are those, is that Aiden and Brady?
Correct.
Shelley? Okay, so, and this happened a month ago?
Yeah.
So anything that they would told police a month ago, that was closer in time to this event?
Correct.
They probably saw it better than you did.
I mean, I wasn't looking when I got hit, so I guess they would have, yeah.
Okay, thank you. I have no further questions.
Mr. Harrison?
Well, you mentioned a couple of times that Mr. Michaels Elijah touched you in
Right,
some way. Did you find that touching to be offensive?
not at all,
Was it intentional on his part?
not at all, and I also informed the police, he's never hit me or showed any aggression towards me.
Thank you. Nothing further.
I'm gonna ask Ms. Harrison, what was the fight about, or the disagreement, or whatever?
Honestly, I don't even know. We were just in a tiff about literally nothing. Like, he had cocked an attitude to me, I cocked an attitude back. It wasn't, I couldn't even tell you why. Even that day, I couldn't even say why.
Okay. So were you in a room at the hotel?
Yes,
And present, there was you, the defendant, and your two children.
correct.
Was anyone else present?
No,
And who contacted the police?
I think, an outside person outside.
Okay, so somebody outside of that room contacted, to the best of your knowledge, it wasn't any of the four of you that were.
I know it wasn't the four of us. As far as I'm aware, when I walked outside to call my kid's dad and talk to him and have him come get the kids, someone overheard me say, "Aaron, don't hit me again," or something like that. But that time I still hadn't calmed down and realized what had happened. So I'm believing that's where that stemmed from possibly, or my kid's dad assaulting him. I'm not sure at what point the cops were called.
Okay. Did the defendant leave the room after the, and for lack of a better word, I'm gonna call it a scuffle?
I mean, he stepped outside with me and the children, but it was right outside the door. Not other than that, he didn't leave at all.
Did you contact Mr. Chickelli?
I did, because if I was even in an argument, I wouldn't want my kids around that. So I did contact my kid's father, correct?
All right. And where does Mr. Chickelli live?
Lake City. I believe he was in Cadillac when I contacted him though, because he was there in like 2 minutes.
All right. And of course, the court takes judicial notice that Lake Cadillac Resort is on M115 on the west end of Cadillac, near where it crosses M50. And when you all went outside, where did you and the defendant go?
Just right outside the door, like 3-4 feet, maybe outside the outside door.
So you were, okay, so you were out in the exterior of the building.
Correct.
The court takes note that there is a McDonald's nearby, right next door to the, I guess that would be the northwest. Thank you. Anything further, Mr. Carnes, based upon my questions?
Not from this witness, thank you.
Mr. Harrison, any further questions based upon those?
Nothing.
Thank you, Ms. Connors. You may step down and return to the gallery. Mr. Carnes?
Thank you, Your Honor. The people call Lindsay Simmons.
Simmons?
Can I have you read from the legit?
Better give it to me, doesn't matter. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may take a seat. Mr. Carnes, your witness.
Thank you. Can you please state your name for the record?
Lindsay Simmons.
And are you employed by the Michigan Department of Corrections supervising Aaron Michaels Elijah?
I am.
And did you receive a police report from the Cadillac City Police regarding an incident on July 13th, 2025 involving your supervisee?
Yes, I did.
And do you recognize this document?
I do.
Is that a copy of that police report?
It is.
Your Honor, the people would move to admit this Cadillac City Police Department incident number 25-001939 and would ask to publish to the court.
Have
Word
it
here.
marked. Hold on, let's have it marked. Nancy is fantastic, but she can only do one thing at a time.
For here.
Go ahead.
Ms. Simmons, did you contribute anything to the compilation of that report?
To the compilation, I'm sorry. of the
Did you
report.
write any of the information contained in that report?
I did not.
Do you have firsthand knowledge of any of the information in that report?
I do not. I was not there.
Have you made any independent investigation of the allegations set forth in that report?
Only to follow up with the law enforcement officer that responded.
And you also spoke to Ms. Connors, correct? We'll cover that in
parties.
just a minute.
Yeah.
Okay. So. Okay, that's where we are then. This report is not your own work and you have no firsthand knowledge of its content.
Correct.
Okay, thank you. I would object to the introduction of the exhibit. I know you're going to tell me the rules of evidence don't apply, but this clearly violates the best evidence rule. It's clearly relying on at least 2 layers of hearsay. I just think it's a,
You can argue its weight. I'll get that, but its admissibility is clear. And the People's Exhibit number 1 is hereby admitted. But again, I understand you'll argue the weight.
it goes to weight. I understand.
Sorry, thank you. Mr. Carnes, did you have any further questions for Ms. Simmons?
No, Your Honor.
Mr. Harrison, did you have any further questions?
I do. Subsequent to the events in question, have you had a conversation with Ms. Connors? Was it more or less consistent with her testimony here today?
She had stated to me that she originally thought Aaron did hit her and then realized that it was probably the cell phone that came
Okay.
out of her hand and hit her in the mouth. And that's what the kids had also told her as well.
And that's essentially what she said here today.
Correct.
Would you agree with me?
Yes.
Okay, thank you. Nothing further.
All right, one moment. Did she say to you why he hit the cell phone out of her hand?
She had stated that she was trying to get in touch with her mom and that he had wanted to try to calm her down before she made that call.
Okay. So in other words, he's interrupted her telecommunication call. No, did she hit the phone?
Did she hit-
She said he hit the phone out of her hand.
You heard her testimony.
Stop. Don't argue with me. I'm asking the question. You don't get to interrupt me and argue with me. I'm just asking the question. I haven't even made a ruling yet. And I'm getting really tired of this, Mr. Harrison. When you don't like something the court is doing, you shut up and you sit there and you wait until it's your turn to talk. Pretty simple. I haven't drawn any conclusions yet. I'm just asking a question. Do not interrupt me again. Thank you. Simmons, she said he hit the phone out of her hand.
Your Honor, she had stated that she was trying to get in contact with her mother
Okay,
and that her thought was he was trying to like calm her down before she made that call. So he was trying to like put her arm down and try to,
so that's what I was looking for. I'm
Yes,
trying
Your
to
Honor.
understand
yes,
how she interpreted it. It wasn't him trying to interrupt her making the call. It was
Correct.
the effort to get her to calm down, which is consistent with what she had said earlier.
yes, Your Honor,
Thank you.
yes.
Any further questions, Mr. Carnes?
No, Your Honor, thank you.
Any further questions, Mr. Harris?
I have nothing further, Your Honor. Thank you.
Thank you. You may step down.
Thank you.
I'm going to take just a moment to review the statement. Thank you, Mr. Carnes. Anything further?
No further proofs, Your Honor.
Any evidence to provide, Mr. Harrison?
I don't think so, Your Honor. I think I'm content.
All right, thank you. One moment. I thought I was done, but there's another page here on the report. For the record, the report is 5 pages long. All right, Mr. Carnes, argument, sir.
Thank you, Your Honor. I think that people have shown by a preponderance of the evidence that the defendant did commit both of these violations. I do think there is an argument, I'm sure Mr. Harrison will make it, that this was not an assault on Amanda Connors based on her testimony, that she didn't find it offensive or harmful. However, she clearly found it offensive and harmful at the time. Count 2, I think, is proven. The statements, Ms. Connors did say that Aiden and Braden Shisheli were reliable witnesses, and what they told police on the day of the incident would be the best evidence. And we have that right here, that they saw the defendant slap the cell phone in her hand, causing her to hit herself with a cell phone. The contact of the cell phone with her face might not have been intentional, but clearly the contact of the cell phone in her hand was intentional. I think that's an assault. I clearly think it's assaultive, or I'm sorry, threatening behavior. I'd ask the court to find defendant guilty of both counts. Thank you.
Thank you, Mr. Harrison.
Even though the standard is low here today, and the preponderance, as we've both noted to you, there's no evidence that my client did anything threatening or abusive in any way, shape, or form. There's no statement attributed to him. What was testified here to today by a live person in court subject to cross-examination was that there was a misunderstanding and he may have touched her arm, but she didn't feel that that touching was harmful or offensive. If we wanted to know exactly what the children saw and said that day, we could have had them testify as witnesses, but they didn't testify. So what we have is someone else's account of what they think they might have seen that day. In the penultimate paragraph on a document used to support the issuance of a requested warrant for a probation violation. I don't know how far we get down that road before we have to come to the realization that upon further reflection, whatever happened that day was not assaultive and was not threatening or abusive behavior on the part of my client. And there's frankly no evidence to even suggest that that's the case that's been brought forth. Thank you.
Thank you very much. One moment. Well, it would have been nice here to know. I don't see anything referenced though. It's like, hold on. There's one thing that I'm looking for. It would be nice to see it in the report as stated either way. In other words, was there any type of consumption? Because it wasn't mentioned by Ms. Connors. And I don't see it mentioned here in the police report. Therefore, I assume there was not. I it would be nice also to know what the fight was about. That wasn't covered in the police report either. Maybe the police officers were more focused on the defendant who had been beaten up by, or at least according to this report, by Ms. Connor's father, children, Mr. Kelly. I suspect that this was a heated issue where both people were potentially in a heated issue, or at the very least, Ms. Connors. Now, this is where it becomes difficult, because then it sounds like I'm pointing a finger to the alleged victim of a domestic violence situation. And clearly, this reminds me of that case. I don't know if they still use it in law school. The one where they talk about assault, where somebody kicks the cane out from underneath a person. Does that one ring a bell? No? No? All right. It's the one they used to use for law schools to teach you about assault and battery, where you don't have to actually touch the person, but if you kick the cane out that they're holding on to, then that's an assault and battery. So was there an assault and battery? At least the contact was demonstrated. Now, this is mucky because I also understand that in situations of domestic violence, victims almost always come to the courtroom and always say, nope, it didn't happen, it was my fault. It is such a problem that, nope, that's why everybody got their time to ask questions and testify. When I was a prosecutor, not one domestic violence case that I could ever think of ever did not involve the victim coming to my window or office and telling me that it was all that her fault or his fault, her fault, and that I was an evil person for prosecuting the defendant still. So, don't really know how much I put value into what Ms. Connor said. Plus, here's another thing. I look here, and this is the one thing nobody focused on, but I think I focused on it the most, and it was on page 4 of 5. This is where law enforcement officers spoke to other people who were at the McDonald's parking lot. I highlighted that McDonald's was right next door. I thought somebody might go into this point, but nobody did. But here's why I thought it was important. There is nothing in here that suggests they heard anything from Mr. Michael's Elijah. The only person they heard yelling was Ms. Connors, calling him a woman beater, quote, end quote. I don't know. I'm sitting on the fence post trying to decide who was at fault here. I can't sit here and say, well, it's Ms. Connors' fault because he had no right to slap the phone out of her hand. I don't care if it was something obviously he intended to bring his arm up and swing it through a portion of air and strike something. That would be the definition of the act for a battery. Question here is there a mens rea? Yeah, he did that. Then the next question is as to the last element, was it offensive or harmful, however slight? Clearly it was offensive because she called to have the father of her children come and take the children away. And they went outside and she continued to express how offended she was because she yelled across the parking lot outside that he's a woman beater. Now, that may have been, and this to me is where it all comes down. that may have been true, that he did beat a woman, but there's no evidence he actually beat a woman. Did he hit the phone out of her hand? Yes. Did he intend to do it? Yes. Was it offensive or harmful? That's the point where it becomes difficult. Because sounds like this ball was rolling down the hill no matter what. Because of two people who were probably, for whatever reason, in some kind of silly fight about something stupid, which is how things happen. Mr. I don't remember if you like to go by Michaels or Elijah. I'm just going to go Michaels. Mr. Michaels, you do not get to touch a woman in any way that could be offensive or harmful. Now, in that split second, you, like a lot of other people, probably more often than, thought you could control a situation. Maybe you even thought you were trying to control it for a good reason, to calm her down. Don't do that. Never, ever works. You can't calm a person down. You can't control a person. Get up, walk away. Let that, if this is what's happening, and I'm not saying it, but it sounds like it even from Ms. Connor's testimony, if that ball of yarn is spinning out of control, go away. Let it spin out of control. You can't stop it. Don't. Now, of course, you do if that ball of yarn is going to cause an injury to somebody, including themselves. That's different. Or the children, that's different. So to be quite honest, I'm sitting here and I don't really know, even right now as the words are flowing from my mouth, what the heck I should do. Because it's really a razor's edge. Preponderance of the evidence is boop, just a degree off to one side of the razor's edge. So, I don't know. Now I can also think of that. It's not a conviction. Really, really, if I did find you guilty of it, the only thing is whether or not I give you any confinement for it. And I already know what I'm likely to do there. So hold on. Whether a contact is offensive or harmful can depend upon the relationship between the two people. For instance, I wouldn't walk up to anybody here in this room, even though I know a few of you, and honk your nose. Offensive or harmful. However, that's it. Now, let's say no, everybody says, hey, no, Judge, you can honk my nose. Okay. So now I honk it, but I do a little twist. Ah, darn it, that's probably too much. So here, you should have walked away. Really very simple. I know it's hard to do in that situation, especially when you're in a relationship with that person, but let that person spin out of control and yell and call mommy and call text messages, go ex-husbands or fathers or whatever, and make a big deal about it. Walk away. Go sit outside. Wait for everybody to show up. Wait for grandma to show up. Wait for Ryan to show up. And whatever you do, just stay away from everybody because there's nothing you're going to do besides get yourself into trouble. Because you've got to react to the other person's tone and tenor at that moment in time. And at that moment in time, well, typically you could have honked her on the nose and would have been okay. When she's yelling and screaming and calling mommy, you don't get to honk her on the nose. So everybody's got to listen here. I think further down the field than I think everybody else does. So here's my ruling. Do I believe that you have violated the probation because you committed an assault upon her to some degree? Yeah. So I'm going to find, everybody's gonna hold on though. 'Cause I know today is not a criminal conviction and I know how the process works and it's by a preponderance of the evidence. And whether or not you maintain a relationship with that other person is all up to you. But whether or not you all seek counseling to figure out whether or not the relationship is worth preserving, that's all up to you. If it's gonna continue to be like this, where you're living in a hotel and everybody's gonna be very short-tempered, then you might wanna rethink it. Because nothing will get better unless you guys work on it together and get counseling. So court finds the defendant of count 2 guilty. Of count 1, not guilty. Count 1, by the way, is the one where it's alleged committed criminal misconduct. Now, again, the burden of proof here is still a preponderance of the evidence. But and at a criminal trial, it would be proof beyond reasonable doubt. While this isn't a criminal trial, and my logic could still result in you being found guilty of count 1, I'm intentionally not doing that because I think this is more a count 2. So I find you guilty of count 2, not guilty of count 1. Please say we can move to sentencing.
Yes, Your Honor.
Thank you very much. Any objection?
No, Your Honor.
All right, thank you. Ms. Simmons.
Thank you, Your Honor. Aaron has been on supervision since April 8th of 2024. The original case was OWI causing injury.
Yep.
Ms. Connors as the victim of that case.
I recall she had injuries to her back.
Yes.
Yep.
Back surgery. He's already had 5 technical violations in August of 2024, and he did 210 days in jail for those. He had a show cause that we canceled in June of this year because he started making steady payments.
Good.
He's been negative on his drug testing.
Good.
Since all of this occurred and was released on bond, he's been living with his Aunt Jennifer in Traverse City, and that seems to be going really well.
Good. Everyone will note, I did not ask Ms. Connors if they've had any contact.
Thank you, Your Honor.
Thank you.
I would recommend at this point in time that we continue probation. I would like to see Aaron go on a tether and keep him tethered to his aunt's house because that separation seems to work pretty well for
Are
them.
they, I didn't ask, are they still in a dating relationship or do you plan, I'm sorry, hold on. I shouldn't ask that question, because if you are, then you'd be violating probably a no contact order.
From my understanding, Your Honor, there's been no contact between them.
I'm gonna interpret that, but the question is there still an interest to continue the relationship, Mr. Michaels?
Of course, I love it.
All right, thank you. I don't want to go into details. Go ahead.
Yes, Your Honor, that's my understanding as well.
Mhm.
But I think the separation, not that they can't have no contact at this point in time, but I think that separation kind of has helped them a little bit.
How, this happened when?
July.
July 13th. Okay.
Yes. And Aaron is closer to work. I did confirm his employment this morning with
Oh,
his
good.
lawyer.
Where's he working?
RCI Construction, or Richter Construction, I think they call it.
Yeah.
So he's been closer to work. He's got a coworker that picks him up right at his aunt's house.
Are you working at Elmwood Township? I think you're doing,
Just finished it.
I'm there every Saturday and Sunday.
All the concrete's for me.
All right, thank you.
He's doing well, Your Honor. So I don't really want to suggest a period of incarceration at this point in time, but I think a tether might make sense just to kind of monitor where we're going for a period of time.
You mentioned no positive drug test. Was there or any issues with alcohol?
When I was informed of this, we don't do ETG testing, Your Honor. We just have the PBT, and we didn't have any issues there either. So
No, all right. So you said he had not tested positive for
Correct.
drugs. I just wanted to, I didn't know if he said alcohol. Sorry, thank you.
thank you.
Good to go. All right, thank you. Your
That's okay.
recommendation besides no jail, continue probation,
Tether,
but with tether.
with a tether.
Copy that.
Yes,
Mr.
Your
Carnes?
What she said, thank you.
Mr. Carnes demonstrating one of the things that most lawyers never learn, and that is brevity. Go ahead, Mr. Carnes, Mr. Nation.
Well, the difficulty here is that there's still an intention to move forward. I understand the court's position, frankly, and I don't want to upset that apple cart. I would like there to be have some ability for her to have contact in spite of the tether. I suppose the tether would be to regulate that he's not in effect stalking her or vice versa, but some mechanism that would allow them to at least be able to talk about what the future might hold for them, aside from any sanction imposed by the court. I just wanted to make that record.
Thank you. What's his credit?
I did check, Your Honor, just a moment. I double checked with the jail, I promise. I had 175 days of credit.
That's what it should be. So you had 7 months before,
Yes.
times 5. Good job. All right, thank you.
Your Honor, for the record too, I'm not opposed to contact between them, like communication contact,
Yeah,
but
but what's a tether do? I mean, really, it doesn't track her. She can come and go anywhere she wants.
Sure.
So, all right, here's what I'm gonna do. Court will. Probation end up.
he received 3 years, Your Honor, so it would be
Oh, good.
April 8th of 2027.
Okay, all right, as long as I had 36 months is what I'm concerned with.
Yeah.
The court continues probation as previously set. The court sentences the defendant to 210 days with 175 days of credit, which means with all your good conduct time, you've already served it, so that's good. The court is not going to add anything else. It doesn't do anything because no one can tell where Ms. Connors is at. And as long as you've got a job and you're working, and I can tell you part of the reason why I asked about if you were working in Elmore Township, because it tells me that, 1, yes, you know about the job. 2, I see them working all the time, which means I know that you're there working. So that means that you're doing what you're telling Miss Simmons you're doing. So, all right. That's the sentence of the court. I'm gonna sign it. You're gonna get another advice of rights. This one will tell you, just like the last 2 times, you have the right to appeal your conviction and sentence in the case that is typically done by filing a claim of right to appeal. If you choose to file a claim of right to appeal, needs a request, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document that Ms. Nyman is going to give to Mr. Harrison once he stands up and walks over.
I'm sorry. Forgive me, Your Honor.
You're gonna place,
Bahamas for-
no problem, you're gonna place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges that you received the other copy that you're gonna take with you. Holy cow, I just looked at tomorrow's doc, or Thursday. Yeah, tomorrow's docket. Oh my gosh. All right, has nothing to do with you. You take that other copy if you wish to appeal, which by the way, I didn't do anything.
Thank you.
Yep. All right. You guys figure this out. If not, stay away from a person if it's toxic. It never works out. And if the other person's consuming alcohol, walk away, go spend the night someplace else. Thank you very much. We are adjourned.
Thank you, Your Honor.